is quite a bit to cover, and I want to make sure that we have enough time for question and answers, as I said. So, in short, there is a lot happening, including as of last night. And as the title screen says, this literally is the update for the month of August, and we are not yet done with the month. So let's jump right into it. Where we are is the enforcement in immigration against all aspects of immigration and immigrants in general is at the highest point we've ever known it to be. Part of that is obviously because that is what this administration believes they were elected to do. But also the other crucial part of it is significant amount of funding, a level of funding that we have never ever before seen for immigration specific enforcement. So the one big beautiful bill, which some of you may have heard of, some of you may be suffering through because of cuts to research grants and things of that nature, has given enforcement on the immigration side, Immigration and Customs Enforcement or ICE, Customs and Border Patrol or CBP, and again, HSI, which is the Homeland Security Investigation, sits under U.S. Department of Homeland Security. But all of the enforcement agencies associated with immigration, Border Patrol investigations, all of it, have been given $160 billion allocation. 46.5 billion of that is specifically earmarked for border barrier construction. 45 billion is for adult and family detention. There is ongoing litigation. Again, as I said, there is stuff happening on a daily basis. Just yesterday, I think the detention facility referred to as Alligator Alcatraz in Florida has been stopped officially by a federal court. But again, litigation is ongoing. There is also 15 billion to beef up ICE's capacity to deport immigrants. There is, I think, a daily quota that has been set for how many individuals have to be arrested and placed into deportation proceedings. But this level of funding for immigration is absolutely unprecedented. And we as attorneys, and certainly you as employers and HR, have to be aware of what this means for you. And it does not, at the very outset, I will say it does not matter whether you don't have a single person at your place of employment that is a foreign national. I-9 enforcement is at an all-time high. We will discuss that. I-9 is applicable to every business in the US, irrespective of whether you have foreign national employees or not. So if there's anybody out there who's thinking, well, none of this matters for me specifically because we don't have foreign national employees, I cannot urge you enough to let go of that thinking and start focusing on the enforcement piece because we are in this for the next, 3 years, maybe more, depending on what happens with this administration in 2028. And this is, as I said, I mean, this is just for the month of August, and we haven't even gotten through the month, right? So yeah. All right, I-9 audits, where are we now? And I've also pulled up some numbers from what I call Trump 1.0, which is the prior administration, so you can get a sense of where we are now versus where we are headed, right? So the Trump 2.0 term, just from January through last week, or maybe earlier in August, but as of this month anyway, from January through August 2025, ICE has served over 5,200 I-9 notices nationwide in a two-phase operation. This is similar to what they did back in 2017, 2016, 2017. We also had significant outburst, if you will, of enforcements specific to I-9s. So we now have 2,540 notices that went out between January and March, and then 2,738 notices that went out just in July. Penalties for I-9 violations have increased, with potential fines up to just shy of 29,000 per violation. This administration is specifically targeting industries where they believe there are more than likely to find a larger number of immigrant workers, whether those immigrants are then documented or not. The premise seems to be if you are an immigrant, you are undocumented, right? And so the industries that are particularly targeted are agriculture, construction, hospitality, and manufacturing. I don't know how many, I know some of you that are attending are in agriculture. I also know some of you attending are in hospitals, not hospitality, but in hospitals. And I have some information about hospitals in particular that I want to go over as well. But this is to let you know that I-9s obviously are a big, big piece of the immigration enforcement, immigration crackdown, if you will. The thing that is significantly different this time around is the focus on employers as opposed to just the employees, and this administration making criminal arrests as well as administrative arrests related to worksite enforcement. And those charges are against employers for knowingly hiring people that are undocumented, or if they had been through an I-9 audit previously, were informed that they may have had suspect documents for some of the employees, but continued to employ those same individuals. We are now seeing a significant spike in criminal prosecutions against employers. So again, enforcement is at an all-time high. You need to be aware of it. The other major pain point for HR is, like the title slide says, right, dealing with a roller coaster ride that you never asked to be on. And this is ongoing, right? There's again changes as of I think this morning, and you'll forgive me if I've lost sense of time and space, but brains are essentially scrambled eggs right now. But temporary protected status or TPS, that is the biggest battlefield right now and the biggest pain point in terms of immigration compliance and I-9 compliance from an HR standpoint. So the temporary protected status was given to nationals of various countries that were either going through war or economic disaster or financial disasters. Some of these individuals or some of the countries have been designated for TPS for as long as 30 years. And all of a sudden, this year, most of it has just gone poof, right? So there's ongoing litigation in federal courts about who gets to stay and who gets to go, and what is this the a more humane approach, if you will, to deciding when these individuals are able to leave or when they are going to be required to continue to stay in the US. Um, so as of today, the if you have employees that are from El Salvador that are on TPS, they are lawfully authorized to continue being employed until September 9, 2027, 2025. Venezuelans lose their EADs as of September 10, 2025. Nepal, Honduras, and Nicaragua, they were originally due to lose their status in July. Then there was a federal court case which extended it up to November 18, 2025. There has been a decision as of this morning, I understand, in the Ninth Circuit, which may allow the administration to go forward with deportations against individuals from Nepal, Honduras, and Nicaragua, because TPS, I think, essentially fell apart this morning. But again, like I said, right, I'm losing track of time and space in terms of trying to figure out what is where. But the most recent updates allegedly, and I say allegedly because this has not been my experience, but allegedly the most recent updates are going to be available on the uscis.gov website. I would also urge you to perhaps follow some of the specific immigrant advocacy organizations, because we are trying to stay on top of this as much as we can. What this means for you as HR is that you need to be very, very proactive in terms of having very good mechanisms where you can track which employees do you have that are perhaps from any of these impacted countries that are on TPS, or also DACA, the Deferred Action for Childhood Arrivals program. DACA currently has not been revoked or terminated, but it just seems like that is the next target. And that'll probably happen, I suspect, sometime tail end of 2026, early 2027, just because we do have midterms coming up, and it would be an enormous amount of political capital to lose it heading into the midterms if they were to take DACA away, right? Much of this is a political game. That's not my politics, it's just a fact. This is a political game. And so I feel like DACA is maybe next for significant disruption. And again, disruptions in terms of employee management and personnel for your own entities. But for now, the one that you really need to focus on are any of your employees that are on TPS, any of your employees that are on temporary work authorizations, because there are certain work authorization applications that receive that automatic 540-day extension. So as long as you have an employee, if you have an employee that is employed based on a work permit and they can show that they have filed a application for renewal, you can use the receipt number in your I-9s, and that allows that individual to be employed for an additional 540-day period, right? But not all employment authorization categories qualify for that 540-day extension, DACA being the prime example, right? So you have to have a very proactive approach in terms of what employees are on what status, when does that expire, what is the current government policy. We're going to talk about an immigration plan. Increasingly, I mean, I've been an immigration attorney since, I don't know, the world was created at this point. I've been doing it for so long. But we used to recommend this for what I call enterprise clients, right? Anytime you have 100, 200 or more employees, then you really need to have internal metrics and systems in place to track every single one of those employees. Unfortunately, we are in that atmosphere right now where it doesn't matter if you have 5 versus 500, you're going to need to stay on top of this, particularly if you have immigrant employees that are employed pursuing to work authorizations as opposed to green cards or US citizens. All right. So as I said, DACA may be the next one on the list, unfortunately. And then now we also have issues with the 60-day grace period. 60-day grace period may not apply to all of you, but the 60-day grace period issues that we are seeing right now is if you have, and the area that we're seeing this most on is for H-1B employees, right? So if there is a separation or a termination for somebody that is on H-1B, that individual typically has 60 days from the last date worked to be able to either transfer to a different employer or to transfer to a different visa status, right? So let's say they go from H1 to F1 or to pack up and go back home to their home countries. If there is a separation or a termination and it was not the employee that was actively resigning, the employer, which is you and your entity, are also required to pay for return fare home for the employee, not necessarily the employee's family, but at least for the employee, you are required to pay for their return transportation. Now, historically, anybody that was within that 60-day grace period, we were able to just transfer them from employer A to employer B as long as that application was filed within 60 days. Increasingly, we are seeing NTAs, which is basically a notice to appear, and a notice to appear is what starts removal deportation proceedings. There have now been multiple cases of NTAs across the country. East Coast, West Coast, Middle America, doesn't matter. They seem to be happening everywhere. It's just a heck of a lot of stress for HR, certainly for the employee, and for employers to have to deal with, because the way that immigration law is practiced, right, very few employment corporate-based attorneys know what happens in the removal part of the practice. A lot of us may not have been to immigration court. We may not be entirely up to speed on what happens. And so for employers, when you're faced with an NTA or when your employee is faced with an NTA, you're also having to scramble to figure out, okay, who is a criminal, a immigration defense attorney that has the ability to go perhaps to immigration court. Now, I will say that across the board, when NTAs have been issued and they are issued against H-1Bs that are either in their grace period or have already had a transfer of employment filed within that 60-day grace period, we have been very successful as attorneys in challenging that and getting the deportation proceedings terminated. But again, it's just disruption that nobody needs to have to deal with, right? So there's that. The other thing is, and this again came out just, I believe, yesterday. So even just for this slide, I've had to make changes this entire week because there's stuff just popping up all over the place. So the other thing that came up yesterday is the Trump administration has now made public that they are proactively reviewing all 55 million visa holders in the US for possible deportable offenses. The standard now is no longer we're going to screen you before you come to the US, but we are now moving to a period of what this administration calls continuous vetting, which means that officials say they have the right to review any and all visa holders' social media accounts for as long as they're in the US, right? Law enforcement and immigration records in their home countries, along with any actionable violations of US law committed while they were in the United States. Now, actionable violations of US law includes violations of laws around protests. So if you are, participating in a protest and you are charged with unruly conduct for an American citizen, that would mean, potentially paying some sort of a minor fine. For anybody that's on anybody that's in the US as a foreign student or on an H-1B, that now potentially means deportation and removal from the United States. Okay. Now, for you as HR, obviously, there is a fine line for you to follow where you can and cannot tell an employee what to post and what not to post on their social media accounts, or what to participate in and what not to participate in. To the extent that you can walk that fine line and inform your employees that it is best for them to steer clear of any and all political discourse, steer clear of any and all protests, whether that is relevant to free speech, whether that is Free Palestine. And the reason I say Free Palestine is because we have had significant issues that have come up with this administration in particular and students in particular around their participation and their advocacy for a Free Palestine. We've got the Mahmoud Khalil case where he was a lawful permanent resident that was put in removal proceedings and that was put in detention center for several weeks. There is the other Turkish researcher who wrote an op-ed with another author. Nothing happened to her co-author, but she was picked up from the streets and was put into deportation proceedings. Both have now been released, but their deportation cases continue, right? So again, as HR, there is a fine line of what you can and cannot tell your employees. But to the extent that you can, I would find a way to inform them that they need to steer clear of any comments that are, especially comments against this administration, comments against this president. Absolutely avoid doing that. For anything that is on social media, I think a good rule of thumb for anybody in the United States right now on visas, including green card holders, and I hate saying this, but including green card holders, lawful permanent residents, steer clear of political speech. Because increasingly, the size of the hammer that is being used to control immigrants is increasingly massive, right? And the enforcement piece is just all out enforcement. Very little room for understanding or empathy there at this time. So careful with this, but also again, from an HR perspective, something that you should absolutely keep in mind. All right. The other thing that's come up is as of January this year, there was a executive order entitled Protecting the United States from Foreign Terrorists and Other National Security and Public Safety Threats. I don't know who comes up with these names in Congress. They are always increasingly long and increasingly silly, but well, that's what we have. The long story short on this one is that these measures are aimed at preventing people from entering the United States that this administration or immigration officers, to their discretion, decide are probably best not allowed in, right? This extreme vetting is expected to lead to has already led to increased scrutiny and potential delays. This extreme vetting includes requiring all visa applicants, including those applying for tourist visas, to divulge all social media and put their account settings to public. So if you're a private person and you'd rather not have everybody and their grandfathers and their associated other family members in parts of that you've never been to and don't care to ever visit, don't want your information being public to anybody, that's no longer an option if you want a US visa, including a tourist visa. You are required to divulge all social media. And this counts again. This is an absolute requirement for any of your employees that are either entering the United States again, even if they are entering on tourist visas, or if they were already in the United States. So for example, let's say you had somebody that is a foreign student, we're just going through the H-1B process right now for applications that were selected in the lottery in April. Those individuals are eligible to start employment October 1 of this year. Some of them may have to go back to their home countries and apply for an H-1B. If they were previously on F-1, they may have to apply for an H-1B visa. Others may be outside of the US seeking to enter the US on H-1Bs. Each of those employees is going to have to make sure that they have divulged every social media account. And when I say every, I mean every. Like, we are literally hearing about people with Reddit accounts that are being denied because during that extreme vetting phase, one of the officers found a Reddit account, and because the applicant hadn't put that in their form, that applicant was charged with deceit, right? That they actively lied to the US administration, and so their visa was denied. Um, so again, some of you as HR take a much more active role in terms of visa applications and the like for your employees. Others of you rely on counsel such as us to advise your clients. I have no problems advising your clients on what to do and how to scrub their social media accounts, but this is something that HR needs to be aware of to the extent that it absolutely positively impacts the amount of time you are likely going to be without employees in the United States, particularly if you have employees that need to get visa stamping done. Certain consulates are now at a 3-month wait for an interview. And so again, I will come back to the absolute necessity of having an immigration plan specifically tailored for your entity so you can track who these employees are and things that you need to keep in mind. And I'm going to go over some pointers on how you can go about creating that. Okay. So first we have this extreme vetting memo that came out in January. We now have this discretionary factors policy, which was issued August 19th. And then we have this other one, like I said, that just came out yesterday. So there's a lot of activity. Now, the discretionary factors policy is also very, very important for HR because it goes back and says that any applicant for any visa category, irrespective of whether they are applying for a tourist visa or if they are applying to come into the United States as a lawful permanent resident, is going to be subject to not only extreme vetting, but that vetting is going to be to the discretion of an individual officer. Okay. So when conducting a discretionary analysis, as the law and as this policy now allows, officers are allowed to consider whether an alien's application for admission was made in accordance with all applicable laws, meaning that they get to decide whether your employment at a prior employer was actually valid. Like, let's say you said you were working as a volunteer. Were you actually working as a volunteer? Does your prior internship actually meet the regulatory guidelines for what an internship should look like, right? And so the level of discretion that is now allowed to individual officers is really, really broad, especially if, and I'm going to try and highlight this, but if you look at this word, the anti-American as a term is not defined in the Immigration and Nationality Act. The INA is what governs immigration law, right? Anti-American as a term is not defined. And so in the absence of a definition that would allow for uniform application across applications, we are left with anti-American being defined by an officer based on what he or she thinks it means. Okay? What this means again for you as HR and for you as personnel managers within your entities is really needing to decide which employees leave the United States and at what point, but also probably some form of significant educating that you need to do of your employees in terms of things that they choose to align themselves with. And again, you're put in a very difficult position because that is a significant issue for you as HR in terms of what you can and cannot say without triggering discrimination and anti-labor law practices, right? And so if you need to rely on outside counsel to come in and do sessions for your employees, that's probably what you need to start doing. But this is starting to get very, very scary very, very quickly. All right. Now, One of the other things that has come up, and this was effective September, actually, this was effective, I think January of this year is when Marco Rubio, who is now the Secretary of State, announced it. We are finally starting to see real world impacts and what that means. So I included it in our August update. But under the Biden administration, because of the COVID crisis as well, the Biden administration and the Department of State at that time had allowed for visa interview waivers, right? So almost all applicants that were applying for visas, as long as they were applying for the same classification, they were not required to appear for interviews. So, for example, if you had a person that was on an H-1B and they were, that H-1B visa had run out at 3 years and they were now required to get a new visa stamp because they had previously already been screened, they weren't being required to go in for interview. That is no longer the case. It has now dropped to the point where if your prior visa was issued more than 12 months ago, you have to go in for an in-person interview. Most non-immigrant visa applicants, including those renewing visas, like I said, so your F1 students, your J1 researchers, J1 physicians, will need to attend an in-person interview. This may impact some of you to the extent that some of your employees have children that are under 14. But again, historically, children under 14 and elderly over 79 have not been required to present themselves for an in-person interview, but that is now no longer the case. Apparently, we're worried about child terrorists and geriatric terrorists. I don't know how else to explain that. One of the things that we are seeing as a direct result of this in-person interview requirement is a significant spike in 221G statistics. So for those of you that may not know what 221G is, when an applicant goes for an interview, the visa officer will give them different colored slips, right? And so some consulates have a white slip, some have yellow slips, some have pink slips, and those things mean different things. But essentially, what that means is that there is additional administrative processing required of that application. Now, that administrative processing might be because they need to do more security background checks on the applicant. It could also mean that they need to do more security background checks on the employer. Sometimes it could mean nothing at all, other than the officer wasn't feeling particularly pleased that morning, that afternoon, and so decided didn't want to deal with it. We're just going to slap a 221G on you. The reason that this becomes important for you as HR is 17% of all visa applications received 221G in 2024, and that has only increased in 2025. I don't have up-to-date statistics for the month of August, but 17% is also already pretty significantly higher than where we were under the Biden administration at the same period of time, right? The other thing for you to remember or for you to take note of is exactly what is written in the next point, which is that average administrative processing time was 4 months, meaning you had an employee that left who was under the impression that they would be back in 2 weeks. You planned for this employee to be out of the country for 2 weeks. It is now 4 months, 3 months later, 4 months later, employee still not able to come into the US because 221G is continuing, right? And once it goes into 221G, it is a black hole. It is very, very difficult to get information, even for attorneys, from the consulate, helping us understand what exactly is missing. What exactly do you need? If it's a specific document, maybe we can provide it in the next 24 hours. Maybe you can then make a decision within the next week as opposed to within the next 4 months, right? But again, these are all issues that are top of mind for us right now, and certainly something that we are seeing HR increasingly having to struggle with or deal with as these policies get rolled out one after the next. All right. The other thing, again, going back to the enforcement piece, which, like I said, we now have $160 billion for enforcement. One of the things on the enforcement piece is audits and various forms of audits, right? One of the things that immigration has significantly increased is site visits. And I don't mean worksite rates. That's a whole other thing, right? And we will talk about that. But for those of you that have H-1B, L-1, O-1 employees, anything that requires a labor condition application, you are basically agreeing to have USCIS or any member of the public really walk in and demand to inspect that LCA, right? You also pay an anti-fraud fee, and this is what part of that anti-fraud fee payment is meant to support, for lack of a better word, is immigration officers coming in and demanding to see certain documents. So all employers are required to maintain LCAs, but you are also required to file LCA amendments and H-1B amendments when required. Bright line rule is that anytime there is a material change, so material change is promotions or demotions where the salary is now different, increases or decreases in salary. Significant does not matter, right? So anytime there is an increase or decrease in salary, if your original LCA that you filed said it was for full-time employment and now the person is being demoted and given only part-time hours, you need to file a new LCA. Changes in job locations. If the new employment or if the additional employment, right, let's say you are doing phenomenally well, you had an office in Seattle, now you've decided to start one in Bellevue, this employee is now going to have to go to both locations. You may be fine not filing an LCA in that case because it is in the same metropolitan statistical area. But let's say you have an employee in San Francisco and now they are going to have to go work out of Mountain View in more San Jose. Those are completely different metropolitan statistical areas, which means different wages apply. So you have to file not only a new LCA, but you also have to follow up with a new H-1B amendment. Failure to file an LCA on time, failure to file an H-1B amendment on time now risks the employer, not so much the employee, but the employer being placed on a supervised recruitment, or potentially if the error is egregious enough and if there's a pattern and practice that USCIS or Department of Labor can show, at worst, it can also lead to blacklisting you, right? Meaning that you are no longer eligible to file for H-1Bs, but it could, at minimum, put you in what we call supervised recruitment, which I wouldn't wish on any employer, because that means before you hire anybody, you have to go through a whole bunch of hoops with the Department of Labor and the Department of Homeland Security before you can even make the offer to the employee, at which point, employee's probably going to have found somebody else to work for. Also, in case of mergers and acquisitions, and this is something I find myself telling M&A attorneys all the time, if you are either in the process of buying an entity or in the process of being bought out, if you are in the process of being bought out and you have foreign national employees that are on visas based on you being the employer, but that is likely going to change. Get an immigration attorney involved at the very beginning of that process. Because if the FEIN number changes, that is new employment, right? So let's say you are the entity that is being bought out. You've done absolutely nothing. The merger's gone through. Congratulations. You rang the bell at the New York Stock Exchange, made a boatload of money. Your employees are now out of status and are going to fall under that 60-day grace period to either get new applications filed on their behalf, or to find another employer, or to pack up and leave, whether temporarily or permanently, right? So anytime you are either acquiring another entity that has foreign national employees, or you are the entity that is being acquired or merging with another entity, you need to file an LCA amendment. You need to file H1 and L1 amendments. L1s, again, there's a whole other issue with L1s there. But like I said, you want to get an immigration attorney involved early in the process as opposed to at the very end. All right. Okay. So again, LCAs, for those of you that have H-1B employees, you cannot deny access into the workplace if it is a fraud investigation. You have agreed to be subject to unannounced LCA visits and FDNS site visits. You cannot refuse them access. So that's one. FDNS site visits sometimes come with the LCA visits, but the FDNS site visits are basically always unannounced inspections conducted by USCIS's Fraud Detection and National Security. That's what FDNS is. These visits basically are meant to confirm the information that you provided USCIS when you filed this petition, right? Which is why they ask to see the LCAs. So if the LCA, for example, is saying this person is going to be working as a lead engineer at this specific location in the city of San Francisco, and you actually have this person working as a software engineer one, and they are not in San Francisco, but they are actually in Palo Alto, that's a problem. And that, under this administration, is going to count as fraud on the part of the employer. The employee is likely going to have their visa status revoked because they were presumably part and parcel of the fraud. But the employer is going to face significant consequences there. Okay. Also, compliance and proper maintenance of LCA folders is a must. My standing advice to HR: if you have foreign national employees and you are required to have LCA folders, do not keep them in the same folder as your I-9s. Because if you get an LCA audit and there is an I-9 sitting there and that I-9 has issues that you may have caught during an I-9 audit, it's already been exposed, right? Keep your LCA folders different from your personnel folders. So your personnel folders that have the individual's health, elections, their W-2s, that all of the other documents that are part and parcel of the onboarding process, employee reviews, whatever else you're required to maintain. Keep LCA folders separate, keep I-9s separate, keep other personnel documents separate. Okay. I-9 audits, like I said, it does not matter if you only hire local or US citizens. You are still subject to an I-9 audit. An I-9 audit and an E-Verify audit are two separate things. An I-9 audit is never meant to be a surprise audit. You will always receive what's called a notice of inspection. The service is required to give you a minimum of 3 days. I have done more of these in the last 1 year than I probably did previously. I'm seeing a trend of probably closer to a week's notice on the NOI before they actually come in and collect the forms or have you drop the forms off. So once you receive a notice of inspection, it will inform you of the time frame that USCIS is looking for, or Homeland Security Investigations is looking for. And then depending on the size of your personnel pool, you might be able to just upload those as PDFs to them, send it to them via email, or you may have to go with, nice big boxes and drop it off at the local office. But I-9 audits are never surprise. You will always get a notice of inspection, a formal written notice of inspection, which tells you exactly what they are looking for. The minute you receive that I-9 notice of inspection, make sure you call Immigration Counsel, not so we can, fudge and any of that, just so we can review the I-9s and make sure you understand before immigration looks at them what the issues are. Now, don't wait for a notice of inspection to do an I-9 audit. I-9 audits need to be done, at least right now. I-9 audits need to be done annually. For some of you that may have a very large volume of people that are being onboarded and offboarded, seasonal workers that are being onboarded, offboarded, maybe you're a tech company that has a whole host of testers that you bring on before you launch specific products, you need to be doing I-9 audits every 6 months just to make sure that everything is clean, everything is clear, everything is documented. Again, I-9 fines have increased significantly, and these fines are not per audit, it is per violation. And so we are back in that era of $3 million and up fines, which we saw during Trump 1.0, we also saw during the Bush administration. So you want to make sure that you are doing this correctly and you are doing it on time. Okay, immigration plan. Like I said, again, this is something that I have always done for clients that are more enterprise level, but I think increasingly it is something you have to do irrespective of how many employees you have. That may, if you have any foreign national employees that are employed under TPS, asylum pending, they have some sort of a work permit, they are on H-1Bs, L-1s, O-1s, you name it, alphabet soup of visas, you need an immigration plan specific to your entity. The things you want to track are the type of visa and the expiration dates of each. Right now, understand also, it is confusing for no reason at all. And it is, I think, designed to be confusing. there are different expiration dates that you need to be aware of, right? So when an individual files for an application, USCIS, US Immigration, issues what's called a 797, which is the receipt. And when you receive an approval, the 797 will tell you what the approval time, like what the time period is that that particular application was approved for. If the applicant is in the United States, typically the I-94, which is what governs how long the employee can actually remain in the US lawfully, is aligned with that I-797, right? So take an example, and this is literally my day yesterday. I spent almost all of it at the Canadian border, helping a client re-enter the United States. This is a investor client. He has an E2 investor visa with an I-797 that is valid until 2027. His visa stamp on his passport is also valid until 2027. And so reason would dictate that when he last came into the United States in January of this year, he would have received an I-94 that also said 2027. That didn't happen. It doesn't matter what your I-797 says or what your visa stamp on your passport says. The I-94 date is what is controlling in terms of whether an individual is in the United States lawfully or not. His I-94 expires tomorrow. And so there we were at the Canadian border yesterday for the sole purpose of needing to get him a new I-94, which is not something you can do outside of a border post, right? So again, you need to have an immigration plan to help you track all of these things. The other thing is for your H-1Bs, again, for some of you that have been doing this long enough, you know what that means. H-1B is valid for a lifetime period of 6 years. The only way to go from an H-1B to a green card application is increasingly via the PERM processing. Right now, you can certainly file for a national interest waiver or an EB-1 or an O-1 if your employees qualify. But historically, PERM processing has been the way to do that. The problem with PERM right now, so the application for immigrant visas sponsored by an employer, is that that process is now taking close to 24 months, start to finish, right? So if you've got an employee that is joining you, they need to have an approved I-140 in order to be able to continue to stay in the US beyond that 6-year lifetime limit, right? And so the pressure from them is going to be, can you get this filed day one? The maximum I think that most foreign national employees are willing to wait is 6 months, right? And so you really need to have a policy which says, if you are on an H-1B, are you going to file this day one? Are you going to wait the first 90 days so you can do an employee review? Are you going to wait 180 days so you can do 2 employee performance reviews and then only file a PERM, right? But you need to get that in writing. So you're not facing a situation where the squeaky wheel gets it done, month one, and then the others that are quiet and working get it done 8 months later, because now you're looking at a potential discrimination lawsuit because it wasn't a written policy. It was discretionary to who came knocking down your door or chewing your ear out on a regular basis, right? The other thing, like I said, is stamping is a real issue right now. Stamping refers to employees needing to leave the United States and get new visa stamps on their passports. Different consulates are at different timeframes. Canadian consulates tend to be anywhere from a year, from 1 month to 3 months for certain visa types, assuming none of them get 221Gs. If you're dealing with applicants from India, China, Pakistan, any of the countries that are considered to be security threats to the US, that process may take longer if they have to go through a 221G process, right? And so again, in your immigration plan, ideally, you also want to start accounting for how many employees do you have that may need to leave to get stamping done? And are you able to stagger them so that you don't have 5 employees that are outside of the United States at the same time, right? The other thing, increasingly, is you want to consider global mobility options. Could you do nearshoring of employees in Canada, Mexico, or any of the LATAM destinations? Does that include doing a joint venture, or is that an affiliate setup in international destinations? What does remote work look like for your organization, right? You also obviously want to account for local rules in the target country, if you will, or in the target city, if you will, with respect to business registration and taxation, and how, again, how does that impact your entity? But increasingly, I think employers, just as a safety mechanism, and again, I went through 1.0 and I find myself saying the same things that I said during Trump 1.0 now increasingly, but nearshoring of employees, using global mobility options, working with firms that are not just US inbound immigration, but also have the ability to help with global mobility planning is already crucial and is going to be much more crucial moving forward, right? That 160 billion for enforcement is essentially changing immigration on its head. It's level of enforcement and level of policies that we have never seen before. We knew it was going to be strict. I think this is a level that even attorneys severely underestimated. Let me just put it that way. Um, right. Immigration policy handbook. So your immigration plan should be a part of your immigration policy handbook, but these are not separate and apart, right? They can be. My recommendation is that you work to have a comprehensive document, which includes a specific immigration plan for your entity, but you also have a standalone immigration policy handbook, which again can be a part of your employee handbook, or it can be a separate handout that you hand out only to your foreign national employees. But increasingly, you need to get this done. The reason for this is because you want to have a clear statement of anti-discrimination policy in these books, right? Um, Especially if you are in California. And I will again, I know that the Buchalter, and this is shameless plug for Buchalter here, but Buchalter has an absolutely stellar labor and employment law practice that is based largely in California, but we also have attorneys in the Seattle office and the Oregon office, and we all work together in concert with each other to help create these policies and these handbooks. And the reason we do that is to make sure that you're protected from all sides, right? The reason that you want that anti-discrimination policy in there is because, at least in California, we're seeing just an absolute explosion of discrimination lawsuits against employers by employees for all manner of reasons, right? So, for example, if you have an employee that is being paid some amount of money, let's say the employer is paying for attorney fees for the employee's immigration processes, you may have a US citizen employee that takes issue with that and says, well, they're receiving a benefit that we're not, right? And so you need to be able to account for all of those things. Similarly, with the I-9 and E-Verify procedures, you need to have consistent application. It's not enough to have it be written and then forgotten about. You need to apply that consistently across the board. You absolutely need to have a tentative non-confirmation procedures and policies. So this is in prior webinars that we've done. I mean, I seem to do these webinars now increasingly, probably every month, if not every other month. But a tentative non-confirmation, or a TNC, is when you have an employee that has provided either an alien number or a social security number, and then you get message from, if you're using E-Verify, you get a message almost immediately saying that this number cannot be validated. Or if you're working with the state and you're filing your state unemployment taxes and all of that, like particularly if you're working with a payment processor, a PEO, they will send you a letter sometimes saying, by the way, these employees came back as non-validated or unable to be validated, Social Security mismatch letters. You need to have a policy for how you deal with that, right? You cannot fire somebody solely because you get a tentative non-confirmation or because you get a Social Security mismatch letter. There is a policy and a procedure that you have to follow before you can terminate that individual. So again, because of that, I will scream from the rooftops as long as I have to. You need to have an immigration policy handbook. You need to have an immigration policy plan. Those things can be part of the same resource, if you will, but you need to have both sides of it. Okay. We have, and by we, I mean Buchalter has an immigration task force, which we started after I joined the firm. It's phenomenal. We have people that are former US attorneys that are a part of it. The employment law team is also a part of it. And this, again, is to give you 365-degree protection in terms of worksite raids, I-9 audits, any questions you have around the compliance piece. I've also authored several articles, and I plan to continue to do that if I can find enough hours in a day to squeeze everything in. But for those of you that are in hospitals and healthcare, there is a specific resource that I have included here for you around navigating immigration compliance in US hospitals. We are now at a stage where, and again, this was covered in prior sessions, but the sanctuaries memo has been pulled. What that means is that Immigration and Customs Enforcement, or ICE agents, now are no longer barred from entering primary schools, educational institutions, hospitals, churches, including in the event of a funeral. They can literally go pick somebody up if that's what they feel like doing. And so this first one talks specifically about hospitals and healthcare and clinics and how you can shield your patients, because there are also HIPAA laws that apply. And so, if you would, please take a look at that. For the rest of you that may be in any other industry, then, please take a look at the I-9 compliance best practices in 2024, which again carries over into 2025. And then, as I said, from the immigration team, I plan on doing these sessions as often as I possibly can because, again, I mean, we're down almost an hour, and this is just for the month of August. So I'm going to stop sharing my screen, but again, if anybody has any questions, please unmute yourself. Feel free to ask. To the person that asked, will slides and recording be available after the session? Yes, I will probably send the slides in PDF format, but the recording will be available on the Buckwalter website. We are also currently in the process of trying to start a YouTube channel just so we can have a singular source of singular place where all of you can have access to all of these recordings that we're going to keep. I'm going to continue to do them, like I said, probably once a month. You should also keep an eye out for some webinars, hopefully specific to global mobility. The Seattle team has 2 people on my team here in Seattle that are certified in global mobility talent management. So we will be including some of that resource specific to global mobility as well. But if you have any other questions, please do ask. I am more than happy to answer them. Okay. The links, okay, I'm not sure what links. I assume the ones that were on the last one. If there's any specific thing that you want, feel free to send me an email. I'm happy to share whatever links I can. In terms of the employee education documentation, it's not so much a documentation, it's more us or me appearing either in person to the extent that you all are in Seattle or in the vicinity, or a webinar for your employees, letting them know exactly what they need to do. That being said, we are also doing these webinars just for general public. And so if one of your employees, we can always share it with you. And if you'd like to share it with your employees and encourage them to attend, that works as well. We're just trying to go with what I call the spray method and try to find every different venue and panel and port like thing that we can find to try and get information out to the maximum number of people in the shortest amount of time, because the rate at which things are changing is actually pretty alarming right now. But happy to be a resource in any way I can. So please just let me know what you need help with. If there are questions, do let me know. I know we are down to about 10 minutes before we have to end. So I'm around. Let me know. If not, we will end here. But again, any follow-ups, feel free to email me. Also, we will put this up, as I said, on the website. We have, for everybody that attended, we do have your emails that you used to register. So if you want to change that, feel free to please email me, and we'll make sure you have a copy of the presentation as well as copy of the videos as soon as that is published. All right. Again, everybody, thank you so much for joining. I am going to log off unless we have any other questions. All right. Thank you. Bye-bye.